Okay, it is about 8:31 and it is Monday, uh, April the 27th, and welcome to week number 4. Week number 4 is the turning point. Now we're starting with the second half of the course. So I thank each and every one of you for being here in the class. Um, for those of you who don't know, I thought I had mentioned before, um, my longtime brother-in-law, who'd been married to my sister for about nearly 50 years, uh, had been battling colon cancer. He passed suddenly Monday night, not Monday night, I'm sorry, Wednesday night last week. So I've been in a tizzy ever since then. So some of you guys know about it, uh, and uh, thank you. Yeah, so it's been pretty tough. That's why my grading is falling behind. I will catch up. So uh, don't worry. The other thing is that starting with next week, the end of this week 4, assignments from weeks 1 to 3, if they haven't been already submitted, will not. So you know. Oh wow. Oh, I'm sorry, Katie, to hear about that. That's woo, my prayers to you for that. Losing a person, a family member like that. Um, wow, that's tough. Um, yeah, it's a lot of people are going through a lot of difficult times, and with this pandemic, it's even worse. So next Monday, I will be doing the lecture, uh, but I'm probably not going to be back to normal until after next Tuesday or Wednesday, because the service that we have for my brother-in-law will be the 5th, which will be next Tuesday. So it's going to be pretty tough. So yes. So thank you, all you guys. Appreciate you. Keep me in your prayers, and we're going to keep moving forward. So again, I'm working to get your grades out for you. So don't. I will get them out. Been working periodically and off and on, dealing with taking care of my sister at the same time. So all right, let's get going here. I'm going to hope you guys are bearing down with this COVID-19 issue. We got some litigation going on in our state, where the governor has extended our stay at home till the 30th of May, but there was a legislator downstate in Illinois who filed a lawsuit and injunction. So it's a battle going on. It's people playing politics with people's lives, and then there are people who's, uh, you know, yeah, people need to understand that life comes over everything else. And so people saying that they're tired of staying in. Well, I'm staying in. They can do whatever they want to do. Uh, I'm going to be 70 years old Sunday, May 3rd, and I'm planning on making it to another year after this, and some more, and some more, and some more. So I'm not rushing into that. So anyway, stay safe, I tell you guys. Listen to what the scientific evidence is saying, not what some people are saying. There are some people that are suggesting using disinfectants, and I'm not going to go into the discussion of that, but you all know what the story was. But anyway, the bottom line is this: is that you know, listen to the medical experts. That's who I rely upon. All right. So anyway, the written assignment for this week is Gant versus Arizona. And so what you're going to do is you're going to apply the rationale from Gantt versus Arizona in a case analysis, answer the questions, is it legal? And then make sure you satisfy the page requirements. And we're going to talk about that in a few minutes when we go into the actual assignment itself. But that's the rubric right there. And that assignment, of course, is due Sunday. All right. And then we get into the week 4 module, current topics. Choose that's around a current case or event relevant to the Fourth Amendment. And then you're going to include options and a short explanation of how the case fits in the overall paper. Include a thesis statement for your project, and then make sure it satisfies the page requirements, grammar, APA. All right, I'm going to talk about that in just a minute. Skipping over the Fourth and Fifth Amendment for next week. So our next lecture will be next week, and you see we'll have 3 more to go after this. And then, of course, after today, at the bottom, the week 4 lecture. And those of you who come to the live lecture have an advantage because of the delay that it takes for me to get the recording out to you. So now let's look at week 4 announcement. Okay, so for this week, searches and seizures. And everybody should know what amendment that involves search and seizures. Anybody know? Yeah, it's the fourth. Notice that this is the 4th week, and it's the Fourth Amendment that's involved. And so the assignment is 7, 8, and 9 of the text. And I sent you the PowerPoints and the corresponding materials that go with that. And then we're going to deal with reasonable suspicion and probable cause and warrants in our lecture for this week. Your discussion assignment is going to involve 2. Remember last week you just had 1 because of the exam. Seizure or not, and then punishing the police. Both of those are very interesting issues, especially the one about punishing the police, um, which involves the Fourth Amendment and the requirements that have to do with things such as what we're doing in our course project. And so finally, of course, those are due initial post tomorrow night, reply post due Saturday night. And then the written assignment, Gantt versus Arizona, and then the Fourth Amendment project current topics. And we'll discuss that in just a minute. And then you know what my motto is all about. Let's take a quick look at the course calendar. And here we go. And you see this is where we are now. And it shows you what your reading assignment is that I just showed you. Again, if you click on it and open it up, it tells you, and it tells you the lecture taking place today, your initial post for the 2 um, discussion assignments tomorrow. Then May 2nd, your reply posts are due. And then May 3rd, your written assignment, and then your Fourth Amendment, which we're going to talk about in just a few minutes. Okay. All right. So now let's go into the module itself. Oh, just a reminder, again, we approach May, as you can see this week, we're finishing out, and then next week we start May. So then the class ends on the 17th. So we'll have a lecture week 5, and then week 6 on the 11th will be the last lecture, and then the course ends on that Sunday, the 17th. All right, absolutely the end of the course. So let's go and look at round 1. Let's go to week 4. And let's go over the assignments. So our current topics dealing with the course project, you're going to find a current case or current event that deals with your chosen area in a 1 to 2 page paper, okay, double space. And you're going to hit all 4 of these bullet points. I kind of already provided that for you with the rubric. And then, of course, for 100 points, this is what you have to do. Okay, and then let's do Sunday, the May the 3rd. Then your written assignment, Gant versus Arizona, 2009 case, limiting the search incident to arrest exception to the warrant requirement. And so you're going to research the case and skim the actual opinion, apply the rationale found in the case, and in a 1 to 2 page paper, report your analysis. And then this is the fact pattern that you're going to deal with this. And the question is this legal under this case? And if so, why? And if not, why? And then make sure that you satisfy the APA requirements, a cover page, make sure it's Word document, make sure you run your papers through Grammarly. You already know that already. And then your discussion assignment, seizure or not, using this fact pattern. And then you're going to answer the following questions in your post. And the second one is punishing police. And so the question is unreasonable search and seizures in violation of the Fourth Amendment. Do you think officers should be criminally prosecuted for violation of these basic freedoms? That's the question. Should police officers be criminally prosecuted? Explain your answer, why yes or why no. Okay. And then the answer could sometimes be it depends. And then of course, your live classroom phrase. Any questions about the assignments for this week? Okay. All right. No questions? Okay. All righty. So then I'll just keep on going with that. Okay. So now let's go into the lecture itself. So as you've discovered that one of the primary and foundational amendments is the Fourth Amendment. And it goes all the way from the pat down to when a warrant has to be issued. And we're gonna talk about the warrant requirement exceptions to the warrant requirement, and then some of the consequences of Fourth Amendment violations, and the difference between probable cause and reasonable suspicion. So we're going to talk about that. Okay, and then you're going to deal with these assignments here. We already talked about these. So we're going to talk about reasonable suspicion, probable cause, and warrants. So what is the difference between probable cause and reasonable suspicion? Well, there's a big difference between the two, and and they are not the same. Some people look at them the same. Um, and then a search is not the same as a seizure, and a seizure is not the same as an arrest. And we're going to talk about all of that right about now. So reasonable suspicion, Terry versus Ohio, the old stop and frisk case. And the purpose for the stop and frisk is basically to determine if the individual has weapons, and it's to make sure that the officer is protected. And so it's a standard that if a reasonable person in the same circumstances could reasonably believe a person has been about to commit a crime. So it has to be the quote we call the reasonable person. That's a person that is dictated by society pretty much. And it depends on the whole, what we call the totality of circumstances, is a key phrase that came out of the case, and based upon certain facts. So when you look at Terry versus Ohio, you'll discover that it is important for you to be aware of the fact that a person can be stopped briefly, ask questions, uh, and um, and not be placed under arrest. But again, they can go to arrest if, upon the reasonable suspicion, if it's determined that that person does have a weapon, and then at that point, then probable cause comes about. So, so offers us, Terry offers us the opportunity to understand that uh, reasonable suspicion, and there's an old term in there. It says that crime is afoot. That doesn't mean it has to do with the foot. It means that it's a crime is about to take place. If you read Terry versus Ohio, you'll see what I'm talking about. And now probable cause requires a warrant. Okay, a warrant, a warrant, arrest. Okay, and it's the highest standard, and it's based upon the reasonable belief that a person committed a crime, also used as the standard by grand juries. So it's different, because in the first instance, you don't have to have a warrant. Now, the Fourth Amendment tells you already what it says against unreasonable searches and seizures. So that's the key language in that. And and it says that the right of the people should not be interfered with or violated except a warrant issued upon probable cause. Now, generally, probable cause is determined by a number of circumstances, and there are some exceptions to a warrant. And we'll talk about a few of those kinds of things. All right. So probable cause is very, 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 very hard to get around without a warrant unless you have one of the named exceptions, and we're gonna talk about those. So when you get a warrant to make an arrest or enter a home and conduct a search, you go before a magistrate or a judge with an affidavit uh, explaining to the judge or the magistrate the reason why a warrant should be issued. And the warrant will only be issued upon a finding by the judge that there was probable cause. Now, there are exceptions, and we're going to talk about these exceptions right now. And there are 6 main exceptions to issuing a warrant. And they're really common sense, quite honestly. Um, First one is if a person says, yeah, you can search, then there's no warrant. However, though, under all the circumstances, the consent must be voluntary. So, for example, if a police officer stops you and pulls a gun on you and says, uh, can I search? And the person says yes. Is that consensual? Yes or no? You said yes. I said, if the police pull a gun on a person and the person agrees to the consent, to the warrant, to search, is that consensual? You didn't pay attention to what I said at the end. It said the consent must be voluntary. Yeah, that's a critical. So willful consent, not under duress, not forced on that person. The gun represents the authority. But just because a police officer is a police officer, has a badge and a gun, and it's not flashing it out, doesn't mean you have to give consent. Maybe you're afraid of the police and you give consent then. It's argued in a court of law that the person did not give consent. However, though, a judge would look at the circumstances under which the person gave the consent. Okay, so that's one way if you consent. So if a person, police officer, wants to come into the house, and they come into a house, and they say, "Can we go into that other room, or can we look into the closet, or go through the house?" Then, if that person does it voluntarily, then yes. So also, now consent searches also involve situations like, for example, let's say, for example, that if um, I rent a room from someone in their house and the police come in, can they give consent to search that room that I rent? Okay, one says no. Anybody else? Anybody else? Okay, okay. So doesn't matter if they own the property or not. That means a landlord can do that with any tenant. So the answer is no. It is. It is. So, well, no, it's not hard to answer. If I rent a room from someone and the police want to search that room, they have to get consent from the person who's the renter of that room. That's their space. And so therefore, it would be the landlord cannot give consent under those circumstances. Some people think the mere fact that they own the building, but think about that. That means then if you live in a multiple unit building and the owner of the building can let everybody's unit be searched. So that wouldn't work. So if that room is what you pay for and that's your private space, then the answer is no. No. All right. So you can find yourself, and actually there are cases like that. I'm familiar with some, as a matter of fact. The next exception is a search incident to arrest. So when a person is placed under arrest, then the officer can conduct a warrantless search of the area in that person's immediate surroundings for their safety or to prevent the destruction of evidence. Okay, so and that's what we call a search incident to the arrest. So the arrest has to be legal first. If the arrest is illegal, then the search is going to be illegal. But if the arrest is based upon probable cause, then in that instance, the officer can check the immediate area surrounding the person uh, for safety or prevent destruction of evidence in that situation. And in the case that we're going to be dealing with today, Gant limited the exception, saying that in the search of a car where a person is arrested, officers can only search the car if they have a reasonable belief that the arrestee's car is within his immediate control. We haven't gotten there yet. With his immediate control, or if evidence of the crime which is being arrested could be found in the car. For example, if the defendant was arrested for driving while a license is suspended, the police can't use the second prong to search the car because there would be no evidence of his driving while his license was suspended found in the car. So you can't do that based upon that crime. So you can't. So it has to be in an area in which the person has immediate control. And like I said, in Gantt, you'll read that the search of a car following arrest, that an officer can only search the car if they have a reasonable belief that the arrestee's car is within his immediate control, or if evidence of a crime for which the person arrested can be found in the car, such as drugs, alcohol, or something like that. If a person was arrested for driving while suspended, the officer can't use that second part, okay, to search the car because there would be no evidence of his driving while his license was suspended was found in the car. Does that make sense? Everybody kind of got that? Yeah, because it's just a suspended license. All right. So now, someone alluded to plain view in the chat box. I saw that real quick. Let's see who. Somebody said something about plain view. What did they say? Is that different from plain view? Well, you'll be able to see in a second. But the answer is yes, it is different. Plain view means what it says. If it's a search incident to an arrest, if the item is in plain view, it's going to be under plain view that the exception, not search incident to the arrest. If the officer is legally searching an area with a warrant or consent, remember, from the owner of the space. Did you see owner of the space? And the officer comes across contraband. In their plain view, they may seize the evidence without a warrant. Okay. Now it is argued that it has to be what it says. It has to be in plain view. So can they go into an area other than where they're allowed to go for their search? For example, can they go through a dresser drawer or look into a closet or those kind of things? No, they cannot. Plain view means what it says. Okay? It means what it says. If you are in a place and the officer smells marijuana, can they search for marijuana? Yes or no under the plain view exception? Anybody else? Anybody else? Okay, some say yes, some say no. The answer is if the officer is able to determine the smell and been trained and recognize the smell of it, then they can determine if they can be allowed to search by asking the question by consent. Or they would be able to, if it's on that person and they smell that person, they're close enough with that person, then in that case, it's considered almost like plain view. Okay, but a warrant will generally be needed for a further search. But plain view means if you come in and you see um, white powder on you can determine if that's cocaine or not. It might not be cocaine, or you could see weed everywhere, or you could see some weed sitting somewhere in plain view. It means what it says, plain view. All right. Some people try to get real fancy with plain view and they mess up, but it has to be read what it says. Well, smelling of alcohol, yep, that's the same kind of concept that applies in a situation like that. That's why I said it would be that person that you check, not all over the place for it. So the answer is yes. Okay. So next is the automobile exception. Now, cars are mobile and cars move and they can get away. And it says that since a car is mobile and there's an increased risk that evidence can be destroyed, officers don't need a warrant to search a car where they have probable cause that there is evidence of a crime within the car. So now, if you're in the car and you're driving and you smell marijuana on a person or alcohol on a person, can you search that car? Do you have to ask for consent? You don't. You don't. Because the person can say no. It's one of the exceptions, Junior. That's what you got to get. It's one of the exceptions. There's an increase of risk that the evidence can be destroyed, so they don't need a warrant where they have probable cause. Probable cause can be determined by the smell of the drugs or the alcohol within the car. Now, can they search the trunk of the car? Probably not unless consent is given. But anyway, it applies. The key deal for mobile exceptions is to deal with things that move. And that's why it says boats. This rule is limited to areas where the contraband could be found. For example, if there's a probable cause that a bicycle was stolen and that's in the trunk of the car that is being searched, the officer cannot open the glove compartment to look for a bike. Okay? So it has to be an area where the item that they're looking for on probable cause could be. So I go back again. Can they go into the trunk on the automobile exception without a warrant? I agree with Junior this time. You cannot. I know of a case of a person who they were getting high in a car, and that and they didn't give consent, they could not open up the trunk. So the answer is no, they cannot without that warrant. But there are cases where it can happen, but on appeal, probably it would be suppressed by a motion that an attorney would file, and that evidence would be thrown out. Exigent circumstances. So what is exigent circumstances? It means what it says, where there is some harm, possibly emergency or destruction, can enter premises without a warrant. Okay, so now you're chasing somebody and they had drugs on them or something, and then they run into the house, or you you come in and then they run into the bathroom. Do you have to get a warrant to go into that bathroom after that person? No, because it could be a moot point. They can flush it down the toilet because that's an exigent situation where there is a threat of harm, emergency, or destruction of the evidence. So where there's someone who could possibly be injured or hurt or killed, that's what we call exigent circumstances. So you don't have to say, oh, I got to go get a warrant before I can search for that. No, you don't. And then the last one, the Terry, well, we already talked about it a little bit, but the Terry, we call it the Terry stop and frisk. See, officers frisk a person if they have reasonable suspicion based upon facts that the person has committed a crime or is committing a crime. That's Terry. And then, like I said, the area for which that they can search is limited based upon all those circumstances. All right. Any questions about any of those exceptions? Any questions? All right. Now, you should be aware that when a person does in fact reach the stage, show you something. There we go. Okay, so now the key thing that you should be aware of is that looking at reasonable suspicion, and look at what some of the things it says. Objectively justifiable suspicion based upon facts, specific facts or circumstances that justify stopping and sometimes searching, as by frisking, that's a pat down, a person thought to be involved in a criminal activity. Okay, that's reasonable suspicion. All right, or we call it a Terry stop. Police officers stopping a person must be able to point to certain facts or circumstances that they observed, the level of suspicion, and that person may be in the process of committing a crime. It's more like a hunch, as it says here, okay? But it's going to be based upon that reasonable person. So I just wanted to share that with you, all right? Now, let's go and let's click on this one. You'll see the difference. So, and it talks about, probable cause, and it talks about due process, and then that means then that warrants have to be, and it says where probable cause exists when the facts and circumstances within that person's knowledge are sufficient to justify a reasonable person believe that something is true. And it is something that doesn't just mean mere suspicion or speculation. I thought, I felt it. No, it has to be at that level. And the reason why is because it would violate the Fourth Amendment without that. Okay. Probable cause is sufficient to justify an arrest or warrant with or without a warrant. And if it's without a warrant, it has to be in one of those exceptions that we discussed. So the police have to let the courts know, the judge, to give them a warrant so they can issue to arrest or search and so forth and so on. And so you can read this whole thing, and it really is pretty good. This is very good. So I brought that out to you so you can open it up yourself. All right. Any questions? Okay. Well, it's going to be so far so good because we are at the end. We are at the end. Any questions about probable cause or reasonable suspicion? Just remember these things. Just remember these 6 things as exceptions. All right. And you're going to find that when you take a test, that's going to be one of the issues there. Let me see what she said. She said, "This is the hardest class I've taken. The law can be tough to understand." That's why we lawyers get paid so well. That's why if you go through law school, you know, that means you got props, okay? That means you understand. Because in law school, what they do is they teach us how to think like a lawyer, but it takes a number of years to really understand how to apply that um, in the real world. So, but yeah, it's not easy. But let me tell you, you get a law degree. I'm telling you, the sky's the limit for you. I'm telling you, I know, I know. I've done so much since I've done that, and then since my major area was criminal law. Oh, I really, you got a long ways to go. As a student said one time, oh, I took criminal law in college. I know now as much as a lawyer. Wrong, 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 wrong. Uh, there are several classes that you take in criminal law to learn how it works. And then even when you get to these tricky things like this warrant, oh man, when we took the bar exam and we had to deal with the issues of the Fourth Amendment, and you had to deal with what we call the multi-state, which is the multiple choice exam. Everybody in the country is taking the same exam at the same time. And usually it's February and July, I believe it is, that they do it. It's been a long time since I had to do that. So since 78. But anyway, my point being is that, and then you have an essay. One little point can change the whole thing. So you have to be very careful not to, as we say, go for the bait really quick in terms of that. Okay. So, any questions about this week's Fourth Amendment? How about a key phrase? Anybody want to guess? We already did that one. Nope, nope, nope. Yes. Hold it. Tyler, you got it. Tyler got it. Probable cause. That's it. Good. Reasonable suspicion was next. Yeah, you were close, but let me say this to you. It's a big difference, as we saw from the chart. And trust me, if it don't fit probable cause, then and it's not reasonable suspicion, the evidence is going to get tossed. And just by the way, so you know it, if in a case that evidence is illegally provided, then what's going to happen is that an attorney like myself, defense attorney, would file what we call a motion to suppress. And when we suppress evidence, what we say is that, and we present arguments in a separate hearing to determine that that evidence was illegally obtained, whether it's in violation of the Fourth Amendment or the Fifth Amendment or even the Sixth Amendment. But the Fourth Amendment is one of the big ones. So yeah. So well, yeah, both are from the Fourth Amendment, but that's because it involves searches and seizures. So that's what the whole topic of today. But remember, you cannot conduct a search uh, unless you have reasonable suspicion, or if you issue a warrant, have a warrant issued, but upon probable cause. And that's probable cause is a concept that really is something. So anyway, so yeah, so once we get that motion uh, granted, where the judge allows the information that was illegally seized in violation of the Fourth Amendment, based upon no probable cause, or based upon it wasn't a reasonable suspicion, or either the test or the search went too far, it didn't fit within one of the exceptions, then in that case, then the judge would what we call quash it, which means that it can't be used in the trial. And so some people say, well, that's unfair. Well, the point of the matter is that and I'm kind of tipping you into something that's in one of your discussion posts, that it's fair because the police have to understand and operate according to the law, as we all have to do so to protect individuals. So, all right, guys. So, uh, again, thank you, and keep me in your prayers this week. Get those assignments in, and I will see you guys next time you see me. I'll be 70 and not 69. Because so anyway, while you guys are submitting your assignments Sunday, I'll be celebrating my birthday. I'm not doing any grading Sunday at all. So because I only get one of those a year. I didn't do any grading for my first birthday, so I'm not going to do any for my 70th birthday. Okay, guys. Thank you again, and stay safe out there, and continue to say thank you. Thank you so much. All right, guys. Have a good one.